jury hearing. All persons having business to move before this court will draw near, give their attendance, and they shall be heard.
Morning, please be seated. First case today for oral argument is 1034, People versus Griffin.
May it please the court. Stephen Sharp on behalf of Mr. Griffin. In light of the elements as charged to the jury, People failed to prove that a pendant necklace was stolen, an essential element of both felony murder and the robbery convictions.
Mr. Sharp, I've looked at that video a few times. It looks like the defendant, your client, gets in the passenger side and reaches across towards the neck of the victim. Do you agree with that?
I do agree that the video shows that individual reaching over towards the victim. Where I disagree is that the people proved that there was a necklace there present at the time. If you look at the video before, well before anything happens, the victim walks out of his vehicle on cell phone talking. And he's right there standing in front with his white shirt on, and you do not see any necklace. People's theory of the case is that that necklace was so visible that it stopped, according to the people's theory, my client in his tracks and set up this whole robbery.
But wasn't there testimony that he always wore, pretty much always wore a necklace?
There was testimony that he frequently wore it from his mother. This is not a necklace that he'd been wearing for years and years. It was a necklace that had been purchased a few months prior. The other thing is, under the people's best evidence of the case, is the last time the victim is seen with the necklace is 6 p.m. the day before from his mother, who testified that he was wearing jean shorts and a white t-shirt and that he had the necklace around his neck. He gets picked up by his brother and goes to a cookout. They don't call the brother, they don't call anybody from the cookout, and significantly, his clothing changed between the time his mother saw him and the time that the police find his body in the car, specifically his shorts. He's no longer
making a weight argument now, right?
Yes. Well, I think that it goes to weight, but it also goes to sufficiency. If you look at the Court of Appeals case in Reed, which was a case out of this department, where they had in that circumstance a very narrow window of time of an hour between the time that the victim in that case carried a bag of $40,000 in a Topps bag that was cut out.
With the two knots on it.
Was that?
The two knots on the
Yes,
back, right?
correct. A distinct bag and very short in time to when it happens. This is well over about 8 hours later. The victim has changed his clothes, is in a completely different location, and the video evidence itself shows that there's not a necklace around at the
I don't want
time.
to get short shrift to your other arguments, but this is sort of the crux of your argument, right? With respect to the robbery. That's what gets you the farthest home, so to speak.
Yes,
Okay.
yes. And, you know, the other thing is, you talk about, watching video. I watched that video hundreds of times. I never see a necklace. And the autopsy and very important questions came out by the pathologist about whether any marks or abrasions occurred to indicate that a necklace had been ripped off the neck in any sort of fashion. And there were none.
Okay. I think we got that argument, and we'll look at it very carefully.
Okay. And if there are no other questions, I'll pass.
Oh, thank you.
Morning, Honors. Brad Osler for the people. May it please the court. I submit that, having watched the video a number of times myself, there's really only one logical inference to be drawn, and that was that there was a robbery of a necklace from the victim. Part of my position, I think, is informed by the idea that the alternative, that this was just an intentional murder or some other form of accident, is just belied by what you see on the video.
Well, both individuals leaving the vehicle seem to be having something towards their body, right?
Correct, they do.
One probably had a weapon, is a surmise. But, so that's part of your argument, too, about there being a robbery.
Yeah, absolutely, absolutely. And just, the perfectly coordinated actions, speak to more than just an attempt to essentially assassinate this person that was sleeping in the vehicle. Unless there's any other questions, I'll also rest.
Thank you. 1036, People versus Rivera.
Good morning, Janet Soames on behalf of Jose Rivera. The first question in this case is whether the court abused its discretion when it resentenced Mr. Rivera without an updated PSI. Although this court's decision in Wilson appears to suggest it did not, this case is very different from Wilson. In
But he'd been in jail for, what, 6 years prior?
Yes, he had. He had.
So
But-
nothing really had changed.
Well, when you're considering the a youthful offender adjudication, there are things that have changed. You've got a window into what's happened to this person on such an important decision as whether or not to grant YO. And in Wilson, the issue was not, the issue of whether or not YO should be granted was addressed in the pre-sentence investigation, and here it was not because Mr. Rivera was not eligible for youthful offender treatment at that time. The second question in this case is when it appears that the judge here confused the question at hand. His question was whether or not there were mitigating circumstances that bear directly upon the manner in which the crime was committed to render Mr. Rivera an eligible youth. And that doesn't seem to be exactly what he determined. Instead, he said he didn't find mitigating circumstances, namely mitigating factors to be considered as requiring youthful offender adjudication. And of course, it was eligibility that he was tasked with doing, not whether or not to determine to find him to be a youthful offender. And third, we would ask the court in the alternative to reduce the sentence here. Mr. Rivera was 17 years old when he pulled the gun. It was a loaded gun, yes, but no shots were fired. There was no one was injured.
But he did chamber around, didn't he?
He pulled back the slide, but we don't know, was it pointed up in the air when he did it? And this seemed to be a confrontation between some people, and we don't know what the threatening factors were. He said that the other people got physical with him, but we don't know exactly. And again, if we had an updated PSI, that question could have been fleshed out a little bit as to what exactly was going on, what were the circumstances under which this gun was pulled. But we know it wasn't shot. We know, we don't know what words were said along at the same time by either the other people or by him or the person who was in the car with him. There's just not a lot of information here. So when you compound that with the fact that the judge seemed to be determining the wrong question, we would ask this court to either remand for another youthful offender adjudication consideration or to adjudicate him a youthful offender, in the alternative to reduce the sentence. Thank you.
Good morning, Dan Gross for the People. I think the dispositive factor here that applies to both the question of YO as well as the harsh excessive sentence is the defendant's display of a handgun. That separates it from a mitigating factors case where this court has found mitigating factors for youthful offender eligibility, and I would submit also would be dispositive for whether the court was unduly harsh and excessive in imposing this agreed upon sentence. I'd also point to the fact that this sentence did satisfy a separate indictment, the burglary charge, which the prosecutor asked to reopen should this court not abide by the agreed upon disposition. Unless there are any other questions, I'll rely on my brief. Thank you.
Thank you. 1037, People versus Don Lewis.
Good morning, Your Honors. Jane Yoon, Legal Aid Buffalo for Mr. Lewis. There were at least two errors in this case that we would submit warrant reversal. First, I would like to talk about the Molyneux ruling. In this case, where the indicted charge was simple possession, the extraneous information that came under pursuant to the court's Molyneux ruling just had no place here in this case and was unduly prejudicial to Mr. Lewis.
I'm interested in the jury issue.
Okay.
Seems to be your best argument.
The potential juror, the for-cause denial you're talking about, Your Honor? Yes, in that case, the judge's ruling in that matter really didn't make a lot of sense. With respect to that juror, when counsel requested the for-cause denial, counsel Counsel argued that this potential juror, as with other two jurors that were previously
Yeah, let me help you out, because I know it's a little bit, I've got some notes right here.
Sure.
But let me, when the response from juror number 13, the juror we're speaking of, I read it to mean that they were sort of, piggybacking what juror 6 said, relative to the credibility, maybe start off at a little higher credibility.
right. And actually, the prospective juror, when asked,
Yeah.
There was 6.
yeah, when asked, prospective juror number 13 about police credibility, prospective juror number 13 said, I do give them a little more credit than that. So it did not make sense when the court denied the for-cause challenge on that basis.
Yeah, in between
there was
that, I'm sorry.
And in the meantime, there wasn't any more questioning of juror 13 to get some unequivocal response, correct?
That's correct, Your Honor. In fact, the court's reasoning in denying that for-cause challenge was simply that the juror did not say there would be a higher level of credibility exercised. But if you look at the transcripts, clearly that's what the juror said, and without any further
I
rehabilitation.
thought the juror was agreeing with 6 that police training taught them to be more observant, so their credibility was a little higher. And 6 was discharged for cause.
Yes, Your Honor.
And if 13 agreed with 6, I don't see the difference.
That's correct, Your Honor. And I would say that that juror should have been dismissed for cause. And counsel was then forced to use the peremptory, so that would warrant reversal.
This is all assuming that the for-cause challenge was correct with number 6.
That's correct, Your Honor, and that's our position that it was. It was also correct when the juror, they dismissed
They got it
juror
wrong
number 2.
twice. Or once, right?
That's correct. Unless the court has any questions on the remaining points, we would just ask that in terms of, in the alternative, if the court is not going to be sending this back for a new trial, the court consider reducing Mr. Lewis's sentence. It's our position that minimum sentences were designed for somebody like Mr. Lewis, who has very little prior criminal history. His only other criminal conviction was for an attempted misuse of food stamps when he was 18 years old, and he was about 45, I believe, at the time of these charges. Thank you, Your Honor.
Thank you.
Good morning, Your Honors. I'll address the juror issue as
Yeah,
well.
let me just sort of prop it up a little bit for you, because
Sure.
6 says something, going to start off a little higher credibility, at least a little bit. Then there's 2 intervening jurors, 7 and 14, that say, I feel everybody's equal. And then we get to 13 that says, I do give them a little more credit than that. I think there, he was sort of, it appears that he was agreeing with 6. But
The first half of Juror 13's response does read that way. I guess, and this is probably my fault, Your Honor, I viewed it more as of a response to prospective Juror 14 than prospective Juror 6. Prospective Juror 14 came immediately before 13. But what I would say is that ultimately the remarks reduce to the fact that officers are first on the scene and that they observe more detail. Neither of those, in my mind, relate directly to credibility. They relate more to testimonial capacity and opportunity to
But
observe.
wasn't that what juror 6 said? They are trained to recognize and pay more attention to details and things like that. So
Well, if you're saying that and saying it makes someone more credible, then yes, it's a problem. But if you're saying that and saying this person is just likely to have more information,
So the fact that I give them a little more credit doesn't mean I give them a little more credibility.
not necessarily, Your Honor.
Okay.
If you read it in kind of more lay terms, it could simply mean that they are likely to have more information than another witness.
Yeah, it's funny, because with 6, if they didn't button it up with this, higher credibility, and then 13 turns around and says, I do give them a little more credit than that.
Right.
It makes it difficult, and they could have probably been buttoned up if,
For the life of me, Your Honor, I cannot understand why either the court or the prosecutor did not attempt to rehabilitate the prospective juror. But it remains our position that the comments do not relate directly to credibility. And I would also point out that the court did secure prior to voir dire an affirmation from that panel, including prospective juror 13, that they would not accord additional weight to law enforcement testimony. Unless there are any questions about the Molyneux, I'll stop there.
Thank you.
Your Honor.
People versus, 1038, People versus Terry Harris.
Good morning, Your Honors. May it please the Court. Kristen McDermott on behalf of Terry Harris. In this case, neither defense attorney ever advised Mr. Harris that he could be sentenced as a persistent felony offender when he turned down highly favorable plea offers, including one to dispose of this case with a misdemeanor.
Yeah, it is a little bit disturbing, but there might be some things that we don't know about. Maybe this is a 440. What was said, you know?
I think this is one of those unusual cases where this can be decided on direct appeal because defense counsel, to his credit, stood up in court and said, neither myself nor the previous attorney ever gave this advice. So we know from defense counsel's own statements what was said between the attorneys.
It wasn't sworn to, was it?
No, it wasn't.
Yeah, and we've been getting more and more of these where, you know, it seems like the lawyers are saying what they need to say. You know, if I was the district attorney's office, I would say, I want to get this individual, I want to be able to ask questions in a row, find out what's really going on, you know?
Well,
If anything.
respectfully, the lower court had the opportunity to have a hearing. I mean, this was put before the lower court, and the court took no action in response to this being raised. So I would point to the third department case in McGee, which I cited in my brief. I don't think that we have to bring a 440. This court can simply send it back for a hearing. Because this was raised, because it was before the lower court, this court can send it back for a hearing on the issue of ineffective assistance of counsel and give Mr. Harris a new attorney. I also think what makes this case worthy of reversal just on appeal is all the other instances of ineffective assistance of counsel that went along with this.
Yeah, I haven't thought this out, but what would happen if that hearing was had and there was some information that isn't part of this record? I guess it would be part of the record if there was a hearing then.
Correct, because the court would be finding that the lower court should have held a hearing on this in the first place.
Sure.
The court, I really just ignored this statement by defense counsel that there was inadequacies in our representation, and the court didn't take any action, and it was required to at least do something.
Okay, thank you.
If I could just point to a couple other instances, throughout the trial, it was evident that defense counsel was unprepared on both the facts and the law. I certainly won't try to go through every single instance, but I think this is a case that's similar to the Court of Appeals case of Oathut, where it appeared defense counsel just didn't know basic criminal law. His arguments during the Sandoval hearing were so
But the court did get the Sandoval ruling correct. You're not challenging the court's ruling on Sandoval.
We are challenging it. We didn't raise it as a separate point heading, but within the subheading in ineffective assistance of counsel, we did ask the court to reverse based on the Sandoval ruling, which we do think the court got wrong because it would be extraordinarily difficult for any criminal defendant to testify if the jury was going to learn he had 10 criminal convictions, and the prejudice of those outweighed the probative value.
The court, as I understood it, excluded 2/3 of his criminal record, but the fact that he had a large criminal record is not the people's fault, or doesn't make it less relevant in those instances. But I understand, but the fact that the defense counsel was aware of all the prior convictions, isn't that something that perhaps the people should get to explore on the 440 motion? As to whether, as he's going through Sandoval, how did he not explain to his client the possibility of a persistent felony offender sentence? It wasn't that he wasn't aware of the defendant's record. He clearly knew the extent and size of the defendant's record. He argued each and every point to the judge.
I don't think it makes any difference what defense counsel's motivation was. It's unquestionable that defense counsel had an obligation to give this information to Mr. Harris at the time. I mean, he had to tell him what he was facing before he made this life-altering decision. So whatever defense counsel's reason, whether he didn't understand the penal law and he didn't understand the persistent felony offender law, or if he just failed to tell him this, I don't think it matters.
But if the defendant had prior experience and knew that he faced persistent felony offender based upon his 4 other felony convictions, would it matter what counsel told him here?
No, I think each time defense counsel, you're the attorney. You have to give this information to your client. I don't think there's any indication that Mr. Harris did know this, and in fact, his letters, when this was finally brought to his attention, his letters indicate pretty strongly.
And if all that's true and it comes out at a 440 hearing, then your client will get a new trial. It seems clear to me on that issue.
That's true. And again, just, I think that it doesn't have to be a 440. This court can just remand.
We understand that's your position.
Okay.
Anything further?
To the extent that this court does not reverse, I would just ask it to take a very close look at the sentence. This is a little repetitive, but this sentence is harsh in light of the misdemeanor plea offer. There's been a number of cases
Well, the
where...
misdemeanor plea offer was made when the victim was unavailable, as I understood it. This is the minimum PFO sentence, isn't it?
It is.
Yeah, and that's a problem, because, you know, I get what you're saying in comparison to what the offer was, with the Justice Niemoyer's point. There were circumstances that probably didn't, that he should have ran with it, you know, because of the problem finding the victim, locating the victim. But, you know, for us to touch the sentence, we would have to touch the PFO, wouldn't we?
Correct, but there have been a number of cases where this court has done that. Even in light of the final pretrial plea offer, which was 3.5 to 7, this is still an enormous escalation. And we're dealing...
You say it's an enormous escalation, and I agree with you in terms of years, but it was the highest second felony offender sentence that he could get, and the next step was the lowest PFO sentence. So it was only one step up. Yes, it was significant in terms of years, but it was one step up from second felony offender maximum to PFO minimum.
That's correct, and I understand that, but nonetheless, the court and the DA's office for months thought that a maximum of 7 years would be an appropriate sentence for this crime.
We'll look at that.
Okay, thank you very much.
Morning again, Your Honors. It certainly seems strange that an attorney would not warn a person with, I think, 31 prior convictions, including 4 felonies, that he could be subject to persistent status.
Yeah, and then you've got the same thing that's similar to the argument relative to the harsh and excessive of trying to get the PFO. It isn't like there's some, you know, idea that, oh, you went to trial, so now we're going to hit you harder. The stars were lined up perfectly with the inability to track down the victim, right?
Correct. I mean, the people's initial offer was 1.5 to 3.
Right.
You know, that's obviously indicative of either belief that the case is weak, or, you know, perhaps that the circumstances don't merit a you know, any sort of lengthier sentence.
What about this idea about this hearing / you know, what could or should or was said maybe outside the record and
This seems like something that's just simply appropriate for an Article
Yeah.
440 motion. It's you know, I think there's certainly some question, and I disagree with the explicit claim that there was a misdemeanor offer made, because the people never suggested that on the record. Maybe there was, you know, I can't say from this
Yeah,
record.
but that would be a 440, you mean.
Exactly. But at the same time, you know, speaking of this sentence, this is a difficult situation in some respects, because the defendant's criminal history, it's hard to imagine one that merits a persistent status more than this.
Well, I don't think there's a claim that PFO wasn't legally allowed or that there was a legal impediment. The question is that it was discretionary and it shouldn't be exercised here.
Correct, and to the extent that that's the question, I think it's a perfectly appropriate exercise of discretion. And I say that only because of the defendant's criminal history. It's somewhat inexcusable that I think this was something like his 10th criminal contempt conviction, and this was one that was committed 3 days after an order of protection was issued for presumably a somewhat similar incident, 6 weeks after he was released from parole. I think the court's confronted with a situation that what else could it do? It's sort of, you have to throw your hands up at a certain point. So I think that the exercise of discretion in that regard was appropriate.
The question was posed to opposing counsel whether it would make a difference if he had been made aware during one of his previous contacts that he was eligible for persistent felon status. Do you agree with that?
I think that would speak to the nature of his decision to reject the offers. It's kind of hard to speculate when there's nothing in the record, of course.
But if there was a hearing, you'd have the opportunity to research that.
Sure, and you know, I think it is, this kind of goes to kind of the point of that question also. It's kind of hard to believe that at some point the defense counsel did not advise defendant of this potential. So it's, you know, I'm sort of in a difficult position in some regards, but I think at least on this record, I don't think we could say it was ineffective assistance, and then with regard to sentencing, I think it was appropriate.
Thank you.
Thank you.
1039, People versus Hamman. Anybody else want to try and tell me how to pronounce this, please? Can you pronounce that for me, please?
Ghanem Abu Ghanem.
What is it?
Ghanem Abu Ghanem.
Okay, thank you.
At least that's my reading.
Okay, it's better than I did. Okay, thank you.
May it please the court, Nicholas DeFonso, appearing for Ghanem Abu Ghanem. I'd like to focus my comments today on point 1 of the brief. Mr. Abu Ghanem's right to a fair trial was violated when the court instructed the interpreters to interfere with witness testimony. This interference was pervasive, prejudicial, and selectively applied against the defense. And counsel was ineffective for allowing this to occur where there was no strategic reason to do so. Now, after reading the briefs, you might say to yourself, this was cross-examination. Couldn't counsel have requested the courts to instruct the witness to answer these questions with a yes or no response? And you know, if so, what's the big deal? Well, there were at least two problems with the court's instruction. The first is it comes down to witness credibility. Right? Witness credibility is inextricably tied to the verbatim response of the witness. In this case, came down to credibility, and so.
But just because someone's speaking through a translator doesn't mean they can ignore the question that was asked and just tell whatever they want to. And the court still has to try to control that, don't they?
Absolutely, Your Honor. And counsel could request that the court do that, or the court could do that sua sponte, and then the witness.
But what if you don't want to? In other words,
what if who doesn't want to?
objection that it's unresponsive to the question, right?
I'm sorry?
In other words, let's assume that you have the ability to object because it's unresponsive. Maybe you don't care. It depends on what the response is, doesn't it? In other words, you know, if it dictates for, calls for a yes or no answer, maybe I don't want to object because I like the fact that he's answering it the way they're answering it.
Sure,
So we got to get there too, right? That the unresponsive answers are, were detrimental. Is that right?
I can see what you're saying, I think,
Yeah.
Your Honor. I think, just to respond to Justice Nemoyer's question, is that if the court is asked or decides to, on his own, instruct the witnesses to answer with a yes or a no, then the witness has to then cooperate, right? So if the witness decides not to cooperate and continues giving non-responsive answers, then that impacts her credibility, especially when, in the context of the questions that are being asked. If she's being asked about prior inconsistent testimony and she continues to give non-responsive answers or explanations or speeches, then that is something for the jury to consider as to her credibility when they're deliberating. Well, the other problem with the instruction is that a lot of these yes or no questions, when the witness is talking to the interpreter's decision of whether or not this is going to be a yes or a no, that that doesn't necessarily involve his skills as an interpreter, his translation skills. There's going to be a judgment call there, or there may be a judgment call there, such that you're not getting the testimony of the witness anymore, you're getting the testimony of the interpreter. It's a fundamental problem with the court's instruction. And I think, if you could just consider, this sort of becomes clear when you take out the fact that there's an interpreter at all. So if you imagine that this was a witness who spoke perfect English, who was just being non-responsive, and an intermediary was appointed to then transpose the testimony to a yes or a no. Like, we can't imagine that happening in the course of a normal trial. So I would just...
I think we have your argument on that.
On that, yes. Okay, so, well, I think this court can rule for the defense and be consistent with the 1996 case of Restivo. There are at least 3 distinctions from Restivo in this case. And the first is that in Restivo, there's actually some ambiguity about where the instruction came from, whether or not it was the court who instructed the interpreter to trim the testimony, or whether it was the interpreter who thought he was doing what the court wanted. But in this case, there's no ambiguity. It was the court's idea. The other distinction is that there were only 2 occasions in Restivo. Here, there are more than 2. There are numerous occasions on the record. And if we presume that the interpreters were following the court's instructions, which we generally do, then we can't really know how many instances of interference there actually were, because they weren't instructed to notify the court every time that they omitted some of the witness's response.
Thank you.
Thank you.
Thank you.
Good morning, Your Honors. Mindy Van Loosen for the people. May it please the court. Your Honor.
This was a difficult case to try.
I think so. I'm not sure if, I'm sure you all caught this actually. With regards to the interpreter, they actually spoke a different dialect than both the Yemeni, the complainant, and the defendant.
Did the prosecution provide one interpreter and the defense provide another?
Your Honor, I know how it is now. I don't know the answer to that question with regards to this case. Now, perhaps would be a different answer. It used to be that you could use the same interpreter for the defendant and the complainant.
In any event, getting back to my first point, that it's a difficult case to try, different dialects. And would you say essentially the defendant's point of view, that is the testimony that he wanted to give, came through?
I would, Your Honor. I think the 3 things that my colleague was saying about this was not selective. Your Honor, this happened both to the defendant and the complainant, first of all. It wasn't pervasive. There was a 4-day trial. This happened, I counted, approximately 12 times, but with the real truncated responses, not just the clarifying, please, have them say yes or no kind of thing. It only happened 3 to 4 times over a 4-day trial. And the people don't feel this is prejudicial. I hope that answers your question, Your Honor.
Anything further?
I'm sorry?
Anything further?
Your Honor, I would only say that we believe the court instructed the defendant and the complainant to both answer in responsive manner in most of the instances. With regards to the direct, that's where most of the clarification happened by the court for the complainant. So this didn't happen as frequently on cross. And again, this is approximately 12 times over a 4-day trial. And I would only say, though, as Your Honors already know, that the trial court has broad discretion in clarifying perplexing issues, including trying to help get clarification with regards to testimony from different dialects over to the jury, and developing significant factual information through its instructions. And we believe here the court providently exercised its discretion in ensuring a fair trial.
Thank you.
Thank you, Your Honor.
Marcus Wright versus Christine Hurd.
If it pleases the court, Deborah Shinta on behalf of Marcus Wright. The points raised by the appellant in this case were not preserved for the appeal. With respect to the guardian ad litem appointment, that guardian ad litem was already appointed to the appellant prior to trial, and it was based upon 2 evaluations. The one evaluator even testified at trial that appellant was incompetent, so it's clear from the record that the appointment was appropriate. With respect to paternity, both parties testified at trial that my client is the father of the child, so it was by stipulation and thus not preserved. And as a result, it was a best interest of the child standard, and that was appropriately applied by the trial court. And lastly, the court did make a proper finding about the release of medical records. That was done on notice by motion with no objection, and that, again, was by consent.
When you
and
say it's not preserved, Ms. Shinta, you're really saying that the mother's not aggrieved because her counsel made the application for a GAL and got it, and she didn't object?
Correct. And same with the other 2 points that are raised, that they were essentially by consent, and she has no ability to argue otherwise on appeal. Thank you.
1041, Yount versus Yount.
Good morning. If it pleases the court, Rebecca Kontz for the appellant mother in this matter. I'll keep it very brief. Basically, the crux of this is the best interest of the child. The mother, while she acknowledges that the father deserves time with the child, she shouldn't be penalized for him moving farther away. They used to have a split custody. And she's just asking for a more even split in the summer, alternating holidays, and whichever parent has Christmas, the other one would have spring break.
Thank you.
Thank you.
1042, Jewett versus Oneida County.
May it please the court, my name is Dennis Phillips. I'm with the firm of McPhillips, Fitzgerald, and Cullum, and I'm representing the petitioners in this action, which involves a hospital project in the city of Utica, and more specifically, a parking garage intended to be
Right, we're aware of all of that.
built on the site. So, Your Honor, in this case, I'm looking at a higher standard for the county of Oneida relative to the taking of private property for a public use. And I think the standard is well laid out in the eminent domain procedure law and the environmental conservation law with respect to environmental review. And specifically, section 204 of the EDPL requires a taker to state reasons for the selection of the property in that location. My adversary, in attempting to rebut that, has indicated in his papers that there has been another proceeding on this case involving landmarks, the landmarks case in the city of Utica. He attached it as Appendix A to his brief. But when you take a close look at that case, you'll see that the alternative locations for the project were in a macro sense, and they were looking at whether the project should be in downtown Utica or should be someplace else.
Can you please do me a favor and pull your mask up over your mouth? Thank you.
Okay, I'm sorry. And so in that case, they looked at 12 different locations. They eliminated 9. They brought it down to 3, and then ultimately they decided on location that it should be in downtown Utica. In this case, we're looking at specific properties. We're not looking at location in a macro sense. So I don't think that that case really has anything to do with this. You know, more importantly in this case, we have the issue of seeker compliance in terms of the environmental review of this property. And again, I would say that the environmental review of this property would relate to locations for this parking garage. At the public hearing, a number of people spoke, both private and public, and they pointed out at the public hearing that there were other locations for this parking garage that should be considered. And very interestingly, representative of the president of the Utica Common Council indicated that there had been no seeker relative to the taking of private property, eminent domain, and that there were other alternatives. So I thought that was a very important fact in this case. Otherwise, my opponent has indicated, well, we can slide by the seeker compliance by calling the County of Oneida an involved agency. But if you look at the record, I would say that the only involvement the Oneida County Board had relative to this action was kind of a letter that was written almost 3 years before the fact of the determination that said, "Good job, that a boy. We like the idea that you have prepared a draft scoping proposal, which would lead into a draft environmental assessment form." But that was draft, and at that point, the County of Oneida dropped off the charts and was never heard of again. My opponent has also mentioned the urban development case coming out of New York City, which was an interesting case in the sense that it was a double condemnation. The city of New York had already condemned a property, but because it involved a project for the homeless and people who were lower income, the UDC came into the picture to actually do a second taking from the city of New York, which already owned the property. And the second taking was what I called a cleanup taking. It was just designed to make things easier for a funding. So I think that case is an anomaly, and it should not apply to the situation. Otherwise, we have relied very heavily on the Lake Placid case, which is cited in the brief. And in that case, the village board in Lake Placid was doing a reconstruction project in Lake Placid, and they did it in 2 phases. One phase when they were just looking at the project in general, but did not contemplate at that time eminent domain. But then when they could not agree to buy a particular piece of property, they said, well, now we have to do an eminent domain proceeding. And in Lake Placid, at least the village in that case did a short form environmental assessment form to comply with seeker. So they complied with the procedure, but they did not comply with the substance. In this case, I don't think we have statutory compliance with the procedure or the substance, because these alternatives that were presented as alternative locations for the parking garage were never considered by the county. So with that, we're asking that this matter be annulled.
Thank you.
Good morning. May it please the court, Christopher McDonald, Whiteman, Osterman, and Hannah for Oneida County. So as you heard during my adversary's presentation, they focus a lot of their time discussing secret compliance. And really their argument is that the county should have engaged in a second and redundant environmental review beyond that which was already performed by the planning board.
So there was one performed for the hospital project?
There was one performed for the hospital project, but critically, that secret review included consideration of the parking garage and the exercise of eminent domain. And so because of that, it was wholly appropriate for the county to rely on the planning board's secret finding statement. That's precisely what a coordinated secret review is intended to do. You know, I'm of the view that the reason that they articulated their secret argument the way that they did is because they're barred by res judicata from challenging the planning board's secret finding statement, having previously commenced that landmarks case and lost. But whatever the reason is, it just doesn't hold water as a matter of law or fact. So as this court is aware, I'm sure, the purpose of coordinated review is to prevent there from being multiple, redundant, time-consuming, costly environmental reviews performed by every agency that has approval authority over a particular project. And instead, you consolidate it with a single lead agency who has jurisdiction to render its determination, and then all of the involved agencies are allowed to rely on that determination. And that's precisely what the county did here. To the extent that they claim that something specific in the county exercising its power of eminent domain required us to engage in a second environmental review, I do think that that's refuted by the East 13th Street Community Association case that we cited in our brief.
What about the time frame? In other words, when it was done and relying on something
in terms of the date that the planning board secret finding statement was passed, well, there's no evidence in this record that anything in there was stale or that any of the information needed to be updated by reason of, say, like a supplemental EIS. And so I think it was wholly appropriate for them as an involved agency to rely on it. I would also note that, contrary to what my adversary has said, their involvement wasn't limited to just saying, hey, we like your scoping document. And this goes to Justice Nemoyer's comment. You know, the secret finding statement of the planning board expressly considered the exercise of eminent domain. It appears at pages, 39 through 41 of the record, and this is in the portion of the secret finding statement that's dealing with community character. And they expressly say, hey, look, there are properties within the footprint of the project that may need to be acquired through eminent domain. Ultimately, it determined that the impacts to those properties was minimal, but it did impose certain mitigation measures for those impacts, including having the county reach out to these affected landowners and try to purchase the property at fair market value before exercising its power of eminent domain. And that's exactly what the county did. If you look at the first several pages of the record, there are numerous correspondence from the county to the petitioners in this case saying, hey, we'd like to buy your property for fair market value. We have an appraisal. If you guys have an appraisal, give it to us. They made the efforts to mitigate the potential effects of eminent domain.
Anything further?
Yeah, just quickly, if I could, to the extent that they've argued in their brief that there's no public use for this project, I would disagree.
The reduction of traffic congestion is a public use?
Absolutely. Reduction of traffic congestion, the public parking that's to be provided for.
Yeah, and this isn't the first time this has been done. It was the Binghamton or the.
Absolutely. I mean, parking is an avowed public purpose, statutorily. I would also note that to the extent they say, well, there's a benefit to MVHS, right? There's a private benefit to MVHS from this parking garage, which admittedly there is. They get some of the parking in that building as well. But that private benefit doesn't destroy an otherwise valid public use. And that's evident from the Denahan Enterprises and Bergen Swamp cases that we cited in our brief. But here, it's also important to keep in mind the type of private enterprise that is getting a benefit from this parking garage. This is a hospital, right? This is a hospital that's going to be operating pursuant to a certificate of need issued by the Department of Health, finding a need for improved healthcare services in the region. And it provides benefits of a public nature, both in the provision of those services, in revitalizing urban blight. Unless you have any questions specific to the EDPL 203 public hearing issue, I'll rest on my brief. Thank you.
943, Seth O'Hara versus Cascades Canada, Inc.
May it please the court, my name is Eric Bailey of Mulholland, Minion, Davie, McNiff, and Byra. I represent defendants Appellant's Greenpack Mill LLC, Normpac Industries Inc., and Mini Mill Technologies. I also represent defendant Appellant's Cascades Canada Inc., Greenpack Holdings, and Jamestown Container Corp., which entities were and are entitled to summary judgment dismissing the complaint and cross claims against them. Indeed, with regard to Jamestown Container Corp., plaintiff has executed multiple stipulations to discontinue this action against them, which apparently have been lost during circulation among the defendants. In any event, the three entities established their prima facie entitlement to summary judgment via the affirmation of Lucy Claude Lalonde, who affirmed that these entities did not.
Yeah, I guess what we have to decide here is it enough to just have somebody with personal knowledge, as you would say, to provide an affidavit of the corporate structures of these various corporations, or is there more needed? Does there have to be some type of attachment showing exactly all the filings and perhaps some other things that would establish it? And your position is if you've got somebody that has personal knowledge of the corporate structures, that gets you there and meets the burden.
That is correct, Your Honor. In the first
And
place,
Greenpack Mill is conceding that it's the owner or operator of this facility.
that is true, Your Honor. In fact, the Court of Appeals has already found that that is exactly what is required, that an affirmation is sufficient in Vivian ATM medical
Yeah, it's
care.
different. There are some cases, but usually it's because they don't have personal knowledge. And then you got to go one step further.
That's true, Your Honor.
Yeah.
What I would also point out is that Ms. Lalonde's affidavit submitted in support of our motion now was not the first one in this case. The record at page 3225 is her first affidavit from 2014, when plaintiff and Valmet knew the contentions that were being made. They did not seek her deposition in order to determine whether the information provided was accurate or to ask questions about it, nor is there anything in the record that indicates that documents were sought based on her original affirmation. Given the
Okay, so if
fact
we agree with you, where does that leave you?
that leads us with the fact that a prima facie case has been established. There is no substantive contention that the information provided is somehow inaccurate, and these three entities should be given summary judgment and dismissed entirely from the case. If I can turn now to Labor Law 241-6.
Your
First thing
position simply is that none of those sections cited apply.
That is correct. None of them apply. I will note that plaintiff has conceded below and here that section 23-1.13 did not apply. It should have been removed by the court below. It was not. We ask that the court do that in this case and remove that section that all parties agree should be removed. However, all of the sections, as Your Honor points out, are inapplicable. Section 1.5C3 applies to safety devices, safeguards, equipments in use. Frankly, there were none in use at all. That's not my words. Those are the words of plaintiff's counsel at page 34 of his respondent's brief. Because there were no safety devices in use, and it is conceded there by plaintiff's counsel, indeed the crux of plaintiff's case is that there were no safety devices in use. This regulation simply cannot apply. 1.7B1 applies in the case of hazardous openings. There was no hazardous opening. It's simply inapplicable. 1.112 applies to enumerated safety devices. Enumerated pieces of machinery, whether we're talking about saws, flywheels, gears and sprockets. None of the enumerated items includes the press machine or Yuli box that were involved in this case. It simply doesn't apply. Section 9.1, by its terms.
I think you have all this in your brief, correct? So I think
Very
you
well.
don't need to go through each and every one.
If I may address Labor Law 200.
Yeah, I'm caught up on the 200 case. I'm caught up on the means and manner portion of it.
And that's exactly
So
why.
maybe you can give us, usually we say we know the facts. I think I know the facts. But I think that's what this rises and falls on the facts.
I agree, Judge, and there are some important facts.
So I'm not, I'm speaking for myself. I'm not really concerned about the premise side of 200. I am concerned about the means and methods, means and manner. And so I guess tell us why that there was no control over the injury-producing work.
Absolutely, Your Honor. I appreciate the question. The fact is, what is
That's what I'm
both,
here for, to make it easier for you.
and I appreciate that.
And if you answer it concisely, then we'll know what your view is, and then we can hear from opposing counsel, right?
Right, because you're running out of time, so.
Very well.
Let's answer it concisely.
What's most important is what is not in the record. The record does not state that my clients gave a punch list to plaintiff's employer with the instructions to do the work that day. It's simply not in the record. What the record shows, and what Kevin Musa of plaintiff's employer testified to, is he received a punch list and he chose to give the punch list to his foreman.
Okay, so let's even assume that they were given the punch list. Tell me about all this power stuff. Who was told not to turn it on or to turn it on? How does that, usually we get a case where you say, okay, you say, I want this particular work done on this date, and you're sort of controlling, the activity that's going on. Here it looks like it's just, there's a bunch of different things going on. And I'm not sure, on this record, I'm a little confused on who was told to do the work on that day.
No one was told to do work that day. That's precisely the point. What happened with regard to Valbit's work is they were told that beginning the day before the incident was when they could start commissioning this part of the machine. Okay. Now, critically, at the record, at pages 1625 to 1627, Valbit testified to the fact that it had its own internal commissioning meetings, that its people met in internal conversation to decide what work they were going to do on a particular day. My clients didn't tell them what work to do that day, didn't tell them how to do it. This was a decision that was made by them.
Who was the person that talked about that directed the power to be on or off?
The directive that was, I believe, Nico of Valbit, who said that he went to Lotus Works to have the power, to have the locks removed so that they could perform their commissioning. He was also
Greenpack Mill asked Valmet, not so at the time, to leave the Yulee boxes in the dried position.
Well, that there's a clearly and frankly, Your Honor, a disputed fact about. The fact is that Seppo Viren, the head of Valmet, their site supervisor, said that Greenpack never said that. He said that again, that was their decision. Is that sufficient to create an issue of fact with regard to means and methods? Your Honor, I don't believe it is, because that ultimately is not what was involved, what controlled what happened in this case. What controlled what happened in this case was the decision to perform the work, the decision to go up there without looking, without putting barrier tape, to push the button, to do the commissioning, and those decisions were made by Valmet at its meeting, not by my clients. With regard to the decision to hand plaintiff's foreman the punch list work, my clients didn't say the work had to be done that day. Yves Gauthier of MRL testified that he would normally receive the punch list and he would determine when the work would be done. Here, Kevin Musa of MRL did that himself. But again, it was done by plaintiff's employer, not by my client. My client simply didn't control the means and methods of what happened. And if there are no further questions, I will rest on my brief.
Thank you.
You can proceed.
Thank you, Your Honor. David Katz from Smith-Sovic, and may it please the court, we represent La Framboise, who is, and we've only appealed from the 241-6 issues.
You agree they're not applicable?
We do believe they're not applicable, Your Honor. I would only like to take just a few minutes, because they were discussed before and briefed very well, on section 9.2. I think that that's probably, in some ways, the heaviest lift in terms of regulatory construction.
That's power-operated heavy equipment or machinery used in construction.
That's exactly the quote I was going to start with. There's two pieces there that do not apply here. One, the press was not used in construction, demolition, or excavation, and for that reason alone, this is inapplicable. Plaintiff's counsel did cite some cases involving a UTV. If you look at 23-1.1, sort of the general fact-finding section, there's a discussion of actually vehicles, but this isn't a vehicle case. And also, I think that the other issue involved a spraying hose. There was a lower court case that was cited involving that. That was something that was being used in the actual act of construction. Also, as to heavy equipment, Article 9 is what really shows the court what heavy equipment is in this context. This is simply not one of those items. A paper mill, the object of construction is simply not the type of thing that's being discussed. The risk that these regulations are aimed at are things that are being used by people to do work, not things that the work is being performed on. And just one more point, and then I will rest on section 1.5C3. While plaintiff contends that there was nothing in use, even if this court were to look at lockout, tagout, or barrier tape, that also is not the type of thing that's contemplated by 1.5C3. It's simply not part of the regulation that
So
it
you're
pertains
saying
to
there's a
equipment.
difference between safety procedures and safety equipment?
Exactly, Your Honor.
We've got some old cases too that say it's not specific enough, but I think we just sort of let those.
Your Honor, I think
Or pasture.
it is a bit of an open question. I think the older cases do say it. I think there are some newer cases that cast some doubt on it.
We just never followed them.
I mean, if Your Honors would like to go there today, we'd certainly appreciate the clarity.
No, thank you.
I do think it is somewhat
But
unclear.
You think you're okay because they're not applicable?
Correct. We sort of
They
went
are
to step
sufficient.
2 on this one, recognizing that that is an ambiguity that does exist in the case law.
Okay.
Thank you very much, Your Honors.
Good morning, Your Honors. Greg Pajak for the plaintiff, Seth O'Hara. I wanted to begin, I'll touch on the ownership issue initially. And what we have here is a situation where we have a conclusory affidavit provided saying, I have personal knowledge and these people or entities are not the
But you
owners.
do have Greenpack Mill acknowledging and conceding that it is the owner-operator of the mill.
That is correct, Your Honor. However,
You just don't believe them, or you want to believe them, but you want to hold additional people in?
no, I just don't think they met their burden here because.
The more the merrier.
Pardon me?
The more the merrier.
The more the merrier. I want a verdict sheet with about 10 people on it, not
Right,
just
sure.
one. I'll be very candid with you,
Yeah, yeah.
okay? So I'd love to have all these people on the verdict sheet.
Yeah, I got to be honest with you, it sort of, it gave me a little bit of pause, okay, and it still does, that somebody can just say, hey, I've got personal knowledge of all this corporate structure, and look at, they're just shareholders of the corporation, and they didn't have anything to do with this. No different than if, I held stock in, in a company, and you couldn't sue me for,
No, of
labor
course
law
not.
violation, but we seem to have a couple cases that stand for the proposition that if you do have personal knowledge of the corporate structures, that gets you there, and you don't need to, do the next step and attach the proper, filings and et
Sure.
cetera to prove.
But the distinction with those cases and what we have here is that we have someone who also had personal knowledge of the corporate structure. We have Yves Levesque, who testified on behalf of Greenpack. Now,
Well, she just said she didn't know.
No, he.
who-
That's a he.
He said he didn't know who owned it. He wasn't certain, he wasn't clear.
Well-
I don't think he came out and said, I think these other entities are also.
My read of his testimony is that at page 1003 of the record, he described Cascades as the mother ship, okay? And that Cascade owns NYAppDiv4, and further, that they also own Greenpack together. He described them all as owners. Now, because he did that, he didn't say, I don't know. He didn't say, I'm not sure, because again, at the very beginning of his deposition, I asked him, if he doesn't know, say, I don't know. And he didn't say, I don't know. So you have a guy here who said, this is what I think. This is my firsthand knowledge. Now you
Yeah, but
have.
he doesn't go one step further. Many times people, non-lawyers say, I own this, and what they really say, if they're speaking of a subchapter S, they say, I'm the owner of this. Well,
Sure.
no, you're the shareholder.
But I don't think any of that can be sorted out on a summary judgment motion when the defense has the burden. They have to clear this up, and they did not with
Yeah,
that
but
affidavit.
How about this? The moving party says they have personal knowledge of the corporate structure. In opposition, it's a little bit grayer than that, as Justice Niemeyer said. In other words, do they really know? They don't know, they're the owner, what does that mean? Do they then have to go one step further to explain the foundation for their knowledge.
And I understand your point, but I think just in the context of a summary judgment motion, all these are interesting questions, but I don't think they can be sorted out. With that testimony floating around out there, and the Green Pack knew it, it was incumbent upon them to clear the air with the affidavit, and they did not do that. Okay? So turning to the Labor Law 200 and common law claims.
Let me key in there, because I may not be, I don't really understand what took place here completely, so.
Nobody
I'm going
does.
to go back to revisit this, but, the typical case with the means and manner is I tell you, look, this is how I want you to do this today.
Right.
And I guess what I'm trying to figure out is what instructions were given by what defendants, and timing, I guess, too.
There's testimony all over the place, and again, this case really is about confusion, okay? It's clear from the record that there was multiple conflicting directives given, and the right hand half the time didn't know what the left was doing. But if you want to know specifically about the punch list, which Your Honor was talking about earlier, at page 3033 of the record, that's where Mr. Musa says that he got it from Ken Carter of Minimill. That's also reiterated at page 3014.
So they had the punch list, but are they supposed to do it that day?
And then you had, yes, what Mr. Musa said was we had to ask permission, and so did Mr. Gauthier. Yves Gauthier also said, once we transferred care, custody, and control to Green Pack, because remember, they signed off on the press to Green Pack, who then turned it over to Lotus Works with another TCCC form. So once the care, custody, and control went to Green Pack and then to Lotus Works for commissioning, Yves Gauthier testified throughout his deposition, which is in the record, we had to ask permission to do punch list work. And at page 2927, it's also said that Yves Gauthier got the asked for the punch list, and it was given to Mr. Musa by Green Pack, okay? Now,
Okay,
there's
so
other
let's assume the timing's not a problem, and let's assume that the control is do the punch list.
Okay.
I want you to do the punch list today. Tell me about who powered this up, and where did that fall with, who gave that direction, and who did they give the direction to?
The testimony is, again, there's conflicting testimony, but my read of the testimony is from Nico Patikian from Mezzo, or Valmet, that he testified that Green Pack, meaning Mr. Levesque, told Mezzo from May 29th to May 30th, we need to keep the Yulee box live and all the hydraulics activated because we have ceramic installation coming in during the overnight hours. That's where the power came from. And remember, that meant that in order for that to happen, the locks had to come off the hydraulics and the electricity to allow this to happen. And again, when you look at Mr. Gauthier's testimony, Green Pack had its locks on the electrical, so those must have been removed for that to happen. And then additionally, when you look at Mr. Allen's testimony, and there's two different systems here, and it gets very confusing, but there's PP 3.4, which is the press, and that's where the punch list was. But PP 3.2 is the hydraulics for the press. And what happened was, according to Mr. Allen, the PP 3.2, the hydraulics for the press, were back in Green Pack's control about 4 weeks before this happened, because there's a schedule which shows that it went back to Green Pack.
Okay, so let me ask you this.
So they told him to unlock everything.
Mezzo's the seller of this
Yes.
to the Green Pack, right? So you're saying that when Green Pack told Mezzo to keep it powered up,
Yes.
it doesn't matter, that's a separate issue, and when Green Pack at the same time, or Green Pack defendants, at the same time required the plaintiff's employer to finish the punch list on that day.
Correct.
It doesn't matter that the direction to power it up went to a different individual because he subjected and required these people to do this work under these conditions.
Correct. They were subjecting my client to the overall harm that was caused by the powered-up machinery. So that's sufficient here to hold them in the case, okay?
Can you sum up then?
Yes, I will. So turning briefly to the 241-6, I can see that the court doesn't like most or all of those claims here in this particular case, but I do think that some are better than others, as in most situations. So the ones I wanted to focus on real quickly, especially is the last one, which is the 23-9 power-operated equipment. I know it's not specifically listed, but I certainly think it's broad enough based on the case law which we've cited to encompass the situation that we have here.
You got yourself coming and going with that. If it's too broad, it's probably not specific enough.
Well, true, I got to be careful there, so I
know
am
what
walking
you're
a
saying.
tightrope.
I'm giving you a hard time.
I deserve it probably, and that's okay. The other one I think that's equally applicable in this particular case is the one that deals with the 23-1.7B. And again, I think they still violated that section. The Rodriguez case, I think, is helpful. So while some of the 241.6 regulations seem to be hanging on by a thread, I think those two in particular are valid claims here and should be affirmed. Thank you.
May it please the court, Robert Scamachi from Gibson, McCaskill, and Crosby. I represent respondent Valmet, and we opposed Greenpack's motion as to the label of 200 and common law negligence claims. I think this court should affirm the ruling below. The Greenpack defendants had a high bar to meet, and they just failed to do it. And I think Your Honor has kind of nailed the issue here. Not only does the record show that Greenpack and Minimill had control over the worksite really from 2020, when the old mill is demolished forward, but the days leading up to the accident, there is specific conduct, and their conduct in this case, they're the traffic cop at the intersection, and they cause the commissioning work to collide with the construction work, and that leads directly to plaintiff's injury here. That's a dangerous condition that they created. The hydraulic valve that was open, if you look at the record at page 1840 and 1849 to 1850, that was left open at
Counsel,
Greenpack.
exactly how is your client an aggrieved party?
How are we an aggrieved party, Your Honor?
Yes, in
That
this
is a
action.
great- That is a great
You've
question.
had your other action.
Yes.
And you were the proper party in that one. I don't understand your involvement in this one.
Well, the Greenpack defendants created the situation whereby our client's work could collide with and cause the injury to the plaintiff in this case. They are the reason why these two events are occurring at the same time. And for that reason, we think the court should deny their motion here as
I
to the
understand your position. I'm just not sure why you get to take it in this proceeding.
And you may not be able to.
Well, we did oppose Greenpack's motion below on these causes of action.
I think we have that.
I think what's clear is that a jury could find that Greenpack and Minimill's acts in conveying the punch list the day after the commissioning has begun, and the day after they know that they had just asked the hydraulics to be left on for the night before, that is enough to keep
And
them
you're
in this
saying that's a premise case under 200, not a means and manner case?
I think it's potentially both, Judge. I think this is one of those cases where there's a dangerous condition that exists, that is the president commissioning, and the owner and the construction supervisor are telling the workers to go back into it and complete construction work. They're complete at odds with each other.
I think we get that.
Thank you, Your
Thank
Honor.
you very much. 10:45, Maloney versus Sir Robert, recall. Oh, and you're recused. And Justice, sorry, I didn't mean to point. And Justice Carney.
You were still thinking
Yes,
through the
recused
last
on this. Oh, dear. I want to note for the record here that Mr. Baldwin had requested an adjournment, and apparently, Mr. Lamb, you are not consenting to that, correct?
Yes, Your Honor, I found out when I was sitting having coffee by exit 45.
Okay, that's fine,
I'd been
that's fine.
notified.
Then I'm going to deny that request if you have not consented, so why don't you go ahead?
Thank you. May it please the court, good morning to the court. Robert Lomb for the plaintiff. I was up several years ago when Judge Fahey was sitting as an associate justice, and I came up as a respondent, and I got up to argue, and Judge Fahey said, Mr. Lam, are you getting up to have us change our minds? So I learned something then that I'm going to be very brief. I'm going to touch just 2 points. And obviously, the question here is whether or not there was continuous treatment.
If there's no continuous treatment, you don't have a cause of action.
That's correct. That's correct, Your Honor. And the history is a really very simple history. Bob Maloney went to Dr. DeRoberts in 2015.
Basically, as I understand your position below and on appeal, is that this is a classic question of fact, which under the PJI 2149 would be presented to a jury to determine the date of the continuous treatment when it commenced.
Absolutely, Your
Or ended,
Honor.
I guess.
Absolutely.
Okay.
So that's your argument?
That's just about it, Your Honor.
And the governing control is what your client believed.
I'm sorry.
What your client believed, your client's intention to return to this doctor. That
Absolutely.
is something that's controlling.
Absolutely. And, interestingly, Judge Neumeier, it's found in 3 places in the medical records themselves. And the record at 81, 110, and 111. And the NP said, will biopsy, since it's been there since excision of DN in 2000.
Well, he never went to any other doctor. He never got.
I'm sorry, Your Honor.
He never went to another doctor. He had missed some appointments.
No.
But he didn't get treatment from anywhere else.
The other point is that.
So your point is that that's a question of fact for a jury?
Yes, Your Honor.
Okay. Anything else?
Yes, just one more, and then you'll be rid of me. And that is the question of cancellation or no-show. And if you look at the record, particularly record on appeal in 88, there's a list of several of the appointments, and there is something that says June 1st, 2016, but there is absolutely no indication that it was a cancellation, it was a no-show. And in fact, there wasn't even an indication that the defendants agreed to. Mr. Maloney showed up for a post-surgical in December of 2015.
Counsel, not to say that they can't show stuff later, but we're at a 30-11 stage, right?
It's the medical records that they included, Your Honor.
Okay, I think we have that.
Saith
Thank
the
you.
plaintiff no more.
Thank you.
Thank you, it's good to see everyone, and goodbye.
Good to see you. 1047 Springwood Village LLC versus Stanley Holdings LLC. I really didn't mean to point at you.
No, that's fine.
Go ahead, Mr. Collins.
Good morning, Your Honor. Please, the court, on behalf of plaintiff Springwood Village, I submit that the trial court erred in denying its motion for summary judgment in this case, which is brought to recover under a note.
Yeah, these are the times that we're glad we're not practicing law.
Oh,
Holy cow. We're only really fighting over there about $19,000.
Yes, fortunately, of the approximately $432,000 that was paid, a substantial amount, $413,000 almost was recovered.
So you believe because you submitted the personal note guarantee and an affidavit of non-payment, you should win, period?
We should win, yes. And the defense was initially, well, the debt was paid by the wire transfer.
right, but it wasn't paid to you, so.
It was not paid. It was paid pursuant to a fraudulent email
Right,
that was
understand.
received by the buyer's attorney that differed from the actual email of Springwood
Yeah.
Village's counsel.
And I saw that the arguments below in response to that were payment, and now they've seemed to change to instead now that the discharge represents a payment. And I guess, as I see it, there's no discharge in the record, first of all, just a receipt.
Correct.
As far as I can tell, and even if there was, it seems to me, well, I'd have to see what it is. There's discharges of mortgages that extinguish debts, and there's discharges that don't.
Yeah, and the discharge of mortgage at most would have extinguished the mortgage. I submit that it was improperly filed because at the direction
Yeah,
of
that's my
Springwood
point.
Village's counsel, it
That-
was to be held in escrow
That's my
pending.
point. In other words, sometimes, when somebody gives you a discharge, when there's a note in mortgage, it doesn't necessarily extinguish the note. It might just say, I don't need a security interest anymore.
That's right.
And we don't know that, and plus, he's acknowledged that the receipt, or the money wasn't received.
He's
So-
acknowledged, and in fact, at, page 4 of the brief, the defendants acknowledged that there is a remaining principal balance of $19,280.
I think we understand all that.
So it's
Mr.
clear that that was not paid, was not received by the seller in this case. And the other argument that the defendants raise is that, there must be triable questions of fact revolving around this whole fraud. But I submit that there are none, and that the proper rule that this court should adopt is that which was adopted by the courts in the two federal cases cited in plaintiff's brief, which is that the party that should bear the loss is the party that was in the best position to discover the fraud and prevent the
And you're
loss.
saying the sellers were in the best position to discover it?
The buyer was in the best position, yes, because they received a fraudulent email instruction with an email address that differed from the actual one. So they were or should have been on notice. Secondly, they received wire transfer instructions that differed from the legitimate ones that had been sent on April 7th, when they ultimately had the funds transferred on April 13. They followed the fraudulent ones, and as those two cases I cite stated, by the simple expedient of saying, hey, you've sent conflicting instructions, which should we follow? A telephone call would have solved it. So they were not only in the best position to prevent the loss and discover the fraud, they were in the only position because the seller's counsel, Mr. Chavone, was unaware of this whole fraudulent email exchange, didn't know what was going on. And for that reason, order below should be reversed, summary judgment granted, and the matter remitted for calculation of interest and attorney's fees on top of the $19,000+ plus.
Thank you.
Thank you.
May it please the court, Gerald Gorman representing the respondent defendant.
Yeah, you're kind of in a weird position here, aren't you?
Well, it's a unique position, I guess, a little bit different, and as the court suggested earlier, the times they are changing, as Bob Dylan would remind us. But first, our position is that the discharge was recorded. It was in the normal course of events, and
Yeah, we don't have it, though.
I'm sorry, Judge?
We don't have it in the record. In the record, I don't know what page 63 of the record, paragraph 9 says the mortgage was paid and discharged of record. This discharge was filed, and then the exhibit to attach, that's attached are two exhibits are the same thing.
The filing receipt for the discharge.
Yeah, and so you would agree that not all discharges of mortgage extinguished notes, wouldn't you?
Well, no, I'm not so sure.
Well, then what do we do? when
This
we-
one certainly did, and I
Well,
don't
we
think
don't
there's any
know.
dispute.
We don't know. I mean, I could discharge the mortgage, and you could still owe me the money on the note.
Well-
The typical one would say it's been paid in full, but we don't know that. Many times people have a mortgage on several lots, and we do a partial discharge, or so I don't know.
Incongruous for the Bank of Holland to issue a new mortgage in the amount that they did if the old one wasn't, the obligation wasn't
disagree with that,
discharged.
but we're talking about burdens, and it seems to me below what you really argued was payment, and above.
Correct.
It seems like you're arguing there was some obligation on the plaintiff to vacate this discharge of judgment, or discharge of mortgage, if they wanted to, for them to be successful with their papers, because this discharge somehow is some type of receipt of payment.
Payment was issued pursuant to emails from Mr. Chavon. Now, the issue has arisen whether those emails actually came from him or not. The
Right,
two
they were
cases.
fraudulent, so
I'm sorry?
They were fraudulent. I mean,
Well,
and I believe we
and
know
that's-
that because wasn't the money recovered from the,
That's where it's our position that the question of fact arises. Who was in the best position to handle this? We don't know. There
Okay.
hasn't been that
we'll have to look
discovery.
into that.
The two cases that Mr. Collins relies on, I would indicate to the court, were both bench trials in federal court, after which the respective judges sifted through the facts presented and made a determination. Obviously, that's, we believe, what should happen
And here
here.
it's a 3213 motion.
Not a 3213, that's what we think. It should.
No, but in this case it is.
Yes, correct.
And those cases are after, a trial.
Correct.
Yep.
We understand that.
Correct. Okay, we believe that, particularly if you look at all the responding affidavits and affirmations, they sound in negligence rather than a 3213 application.
And we'll check into that.
Thank you.
Thank you. 1048, Thomas Bruckle versus Town of Canisius.
I want to see if she left.
Oh,
I don't know when to leave it.
oh, I didn't realize that. I'm sorry, Judge Winslow is recused on this case. Thank you. Yeah.
May it please the court, John Mancuso for the appellant, Carl Myers Enterprises, the developer in this case. Supreme Court's award of summary judgment in the absence of a pending motion based on a decision that was drafted by petitioner's counsel that awarded several forms of relief that were never pled, including criminal penalties in a civil case, should be vacated, and this proceeding just remanded for further proceedings before Supreme Court. The law is well established. In the absence of a summary judgment motion, Supreme Court lacks jurisdiction and authority to render a summary determination. Petitioner's principal argument appears to be that this is a pure Article 78 proceeding. I think the record belies that contention. These two proceedings were styled as hybrid proceedings. They filed a notice of petition, summons, petition, complaint, and I think more critically, they moved for summary judgment with respect to one of the two cases, Bruckle 2, which the Supreme Court had denied in its entirety, and ordered discovery be conducted in this case. And while I recognize there is 3 years of passage of time, there doesn't seem to be any suggestion that anything additional by way of proof or otherwise was actually submitted to Supreme Court when they effectively then rendered a decision at the tail end of 2019 with Justice Ark's pending retirement. Informal emails and letters, these types of exchanges we would submit are not a substitute for a formal motion. What should have occurred in this case is petitioners, if they felt the need for summary adjudication, should have made a motion under 3212 and or 7804 to renotice effectively the return date on the Article 78 proceeding, or in the event there were questions of fact, the court should have ordered a trial. None of those things were followed. And in doing so, I think there's an extreme prejudice here to the developer in this case. We have a situation where...
You gotta take it all down.
What's that, Your Honor?
You gotta take it down, right?
Back down to Supreme Court.
No, but you have to take some.
Oh, yes, the prejudice, yes, Your Honor, sorry, I apologize. The prejudice, yes, in addition to the forfeiture of having to remove the structure itself, we have a significant monetary penalty that could be imposed against the developer, which is very clearly...
But you knew that was always possible because they did seek an injunction, which put you on notice that if your actions were improper in building this, you might have to take it down. If you went forward in light of that, you can't say, oh, I pity the poor orphan who killed his parents.
Yes, Your Honor. With respect to at least the construction aspect, there was a restraining order put in place, and so beyond that point, though no further construction had been undertaken, there was a significant amount of construction that had been done from the building permit issuance until the TRO was issued.
And the argument was below, or at least in the one that came up here, is that it was beyond the footprint that was originally approved.
Yes, Yes, Your Honor, and the case that was appealed in a related proceeding before the zoning board, which has been remanded, and to my knowledge, is still pending in front of Livingston County Supreme Court on them.
So all these should be heard together below, is your view?
Whether they're consolidated or joined for interests of economy, I think everything should be heard before Supreme Court on the merits. I think it was premature and improper for this decision to be issued when it was issued, if for no other reason than the criminal penalties that were issued in the case. Briefly then, I will just turn to the issue of waiver because I know it was a principal point raised in the brief. We think that it fails for several reasons. First, we don't think there was anything to waive in the absence of a motion. Every case they cite, there was a motion pending, there was a trial, there was something where there was a formalized practice. And we would also submit these are pure issues of law on the face of the record. We cite very little bit of the record to begin with, which is evidence of the fact that these are really legal issues that this court should reach and warrants complete reversal. Thank you.
Thank you.
Glasses already going. All right, good morning, Your Honors. John Tantillo for petitioner respondents Thomas Bruckle, Patricia Bruckle, Sally Hurth, and Robert Siracusa. I'd like to pick up right on that last thing that my opponent said. They've cited very little of the record. I don't think that really stands for what Mr. Mancuso suggests it stands for. The reason they've cited so little of the record here is they've offered no argument on the merits. Not one word of their 45 pages of briefing is offered to say that this building should lawfully stand.
Because
Now,
at this point, well, that's not what the argument is about, correct? At this point, the argument is whether or not the order that was signed and is proper, correct?
well, that's what they've elected to frame the argument as, but they did raise arguments on the merits as it relates to the monetary relief. They argue that that's not available in this proceeding, but they don't argue that, oh, we lawfully built this building. I think that's an implicit admission of the fact that they recognize they didn't lawfully build this building. If they thought they did, like their arguments on the money, they would have put it in their brief. Which goes to essentially the issue of waiver. This case has been pending for almost 5 years. The issues that make up this appeal were brought to Mr. Mancuso's predecessor's attention 4 months in advance of the decision. Mr. Mancuso's predecessor was given multiple opportunities to weigh in on these and elected not to do that. Judge Ark went so far as to reach out directly to Mr. Putney and ask if he has anything in response to our submissions, and he offered some nominal opposition, but nothing to the extent of what was in this brief. These issues could have been addressed quickly and efficiently before Judge Ark if they were raised there, and they chose not to do it. Briefly on the standard of review, we submitted that this was an issue of abuse of discretion standard. Article 78 proceedings afford trial court judges the discretion to fashion a remedy. They're able to choose remedies from, for instance, remanding to the boards, annulling a decision, issuing their own decision on the subject question, or ordering that unlawful conduct be undone. In electing which remedies to apply, that's the trial court's discretion. Mr. Mancuso suggested that the court should, even if it is an abuse of discretion standard, substitute some discretion, citing the case of Von Bulow. I looked at cases citing that, and as far as I can tell, that rule has only ever been applied to modify whether or not someone is a sex offender from a level 3 risk to a level 2 risk, so I think that's entirely inapplicable to this case.
What about the issue about the decision and this invitation to submit proposed decisions?
Yeah, on that I think...
This one and the requirement that it be concise, clear, and consistent.
Yeah, I think the first response to that, again, has to be the waiver issue, is that if they had an issue with that, they should have raised it then. But I would also highlight the fact that...
Did anybody really know that, what was really going to take place, that if I chose not to avail myself of that, and then I get a decision that is nearly identical to a proposal by the other party?
Well, I think,
Maybe at that point, I say, that's not fair.
I think what the court expected was everyone to submit, their arguments here. This is a case that was briefed and argued, I think, roughly 3 years prior to this. I think what Judge Ark was looking for was a refresher on the issues, and this was a way to give everyone a last opportunity to resubmit their arguments before a decision was issued. I think I was frankly shocked that nobody else, or well, that Mr. Putney didn't put a response, and I know the town had stopped participating by this point. But even after we submitted our decision and they had a chance to review it, they elected still not to submit a proposed decision. And then as
I'm sorry, I didn't catch the last part of that.
so even after we submitted our proposed decision and they had an opportunity to review it, they still elected not to submit anything when the court again reached out for further comment.
It's an odd situation. We're going to have to look into it very carefully.
Yeah, I would say that to the extent that CME does attempt to offer authority on this, none of the authority in their brief is accurately cited. I think it's all kind of out of context in those decisions, and there is no rule that CME is able to point to that says that this is not permissible.
Okay, thank you. We'll look at that.
As far as the lack of an outstanding motion, these are summary proceedings. My opponent points out the fact that these are hybrid proceedings, and that may be the case, but that doesn't mean that the summary aspect of those proceedings is not summary. It's in Article 78. If there's other stuff that remains after the Article 78 is addressed, then it may remain. But the Article 78 portion of this is still a summary proceeding. Pending before the court were 2 summary Article 78 petitions, and, as Mr. Mancuso declined to point out, a pending motion for a permanent injunction. There was a motion before the court seeking this building being torn down, and that motion was heard and decided.
Okay, we'll look at it. Anything further?
As far as the monetary issues go, I'm a little confused as to why that issue is up on appeal now, because in reviewing the decision, no monetary relief was awarded. The trial date was set for the issue of damages, but no damages were awarded. So to the extent they argue that no damages are warranted here, they have the opportunity to argue that at the subsequent trial. Okay. And no penalties were awarded. My original proposed decision had penalties levied, but Judge Ark removed that from his decision. It was instead attached as kind of a stick to encourage CME to comply with the permanent injunction, which I think is well within Judge Ark's discretion to include in the decision.
Thank you very much.
Thank you.
Nationwide Affinity Insurance Company versus Ridgewood Diagnostic Laboratory, LLC.
Good morning, Your Honors. Alan Hollander for Nationwide Insurance Company. May it please the court. I'm here today in opposition to appellant's appeal. We believe that the decision from the trial court should be sustained. Nationwide's motion for summary judgment clearly shows that we proved our prima facie case.
And we've had several cases basically identical to this. Correct?
We did have one case prior, another Nationwide versus Ridgewood with the same plaintiff and the same defendant, where the same trial court found that they failed to appear for EUOs. We clearly showed that we proved our prima facie case, that we timely noticed the EUO, meaning that the EUO was noticed within 30 days of all of the bills or claims being received. We showed that we timely
Yeah, the big issue is this objective justification why you're requesting it. And as I understand your position, your position is you don't have a requirement in the first instance, but even if you did, it was in those letters.
Correct. It's not part of our prima facie burden to give it, but they did ask for it, and we did provide it. So there's really no issues of fact to be decided by.
Thank you.
Perfect. Have a great day.
You too. Jose Lagares versus Carrier Terminal Services, Inc.
Your Honor,
Yeah, and I understand that you had several opportunities to request oral argument, and you declined, and I understand that you are asking for 15 minutes at this point. I will tell you right now, normally we wouldn't give you any time, but I'm willing to give you 5 minutes keep it very brief, because there is no excuse for not.
Judge, it dealt with the substitution. Brian Forbes was originally listed. I missed it. I admit that. 5 minutes. I'll be as quick and brief as I
Thank you.
can. Please, the court.
As much as you can, you've got 5 minutes.
Thank you. So as far as I'm concerned, there are 3 issues. The first issue, I don't think this court, we appealed both decisions. There was papers that were submitted that we abandoned our appeal. We did not abandon our appeal. All the record contains both motions, both decisions, both records, and we didn't abandon the appeal. With regard to the claim for common law indemnification, the court issued an order for unconditional common law indemnification. Now, I would agree that it's conditional common law indemnification. There's been no verdict, there's been there was no decision at the time for a judgment. It doesn't even accrue. And as far as what the opposition cited to one particular case, which was the Collier case versus Kmart, in that case, they did take away the word conditional to award attorney's fees. You know, if attorney's fees have accrued, they exist, and that's something that they're entitled to. But to get unconditional means they don't have to pay. It's going to come down to us.
Yeah, we understand.
Okay.
And it may just be some loose language with.
And I agree.
Conditional,
I agree. I just can't have that language for the future cases. That's the only reason I argued that. And then the last issue is whether or not there was a question of fact with regard to whether or not Speed or Carrier had any responsibility in this case. And the most important thing is that we know that Speed and Carrier, they're intertwined, the companies. Speed did work for Carrier's buildings. They didn't charge them any money. The most important part of this is they agreed. There was numerous different testimony about work that was performed on that roof prior to my clients going up there. And what was very important...
I thought it was 10 minor repairs over 5 years.
Correct.
And they didn't actually take off the roof. They just fixed open seams and leaks.
That's not the testimony. The testimony is that they did remove, and it could have actually been the removal of decking. And there's several instances in the record where they talk about removing of decking. At page 887, there was testimony that not all the decking was the same. It wasn't the original decking. And if they removed the decking and they didn't put the right size decking on, they didn't weld it down to the I-beams, then not only should they have noticed, they created the condition. Now, what they've done in this case, and this is where I'll shut up and sit down, is they provided no documentation. Carrier was brought into the case early. Speed came in late. We were in the case later. One of our witnesses testified without the assistance of counsel prior to us being brought in the case. We asked for documentation to show what work was done on that roof. They don't have any. They don't have anything to show, did they buy decking? Did they buy roofing? They don't have any. The witnesses that they produced weren't there for that period of time. So they don't know what work was done. They had 14 people that worked on that roof, 14 different people. Not one of those people, any one of them, were produced to say, hey, we never removed any decking. But clearly, this decking wasn't rotted. It's not the original decking. This decking was not rotted. It was not sagging. What it was not the right size and not put down properly. And that clearly is a question of fact. I have a right to have my client, they have to prove their case. They did not prove that they didn't do anything.
Yeah, so this is really, this is limited under 200 or negligence under a property.
They're the owner of a property. They have a
Right.
non-delegable
It's not
duty to make
means
their
in
property
manifest,
safe.
right?
Okay,
Thank you.
thank you. And thank you for being indulgent, since you didn't think there'd be any argument.
Thank you, Your Honors. May it please the Court. Jenna Klusek, I'm here for Carrier Terminal Services.
Yeah, I guess the real issue is whether or not, I buy a piece of property, I don't know any better, versus if there was something done to this particular portion, the roof, and whether or not they either saw it when they were up there or they created it, and is there a question of fact as to that? And as I see it, I think nobody disagrees, it's that this is a 200 condition.
Correct, Your Honor, it's a.
Not a
it's
means and matter case.
Correct, not a means and methods. Respectfully, Your Honors, there is not one single piece of evidence in this entire voluminous record that even suggests by way of inference that Speed or Carrier ever exposed this decking. The testimony is Justice Niemoyer stated, that they patched open seams on the roof. And that's pages 882 to 883 of the Record on Appeal. It's testimony from David Clare, who was the Director of Maintenance for 20 years for Mr. Savarino and worked on this property. There was different color decking because the decking had been replaced before Carrier purchased the building. There's no ambiguity about that. There's no question of fact about that. That was clearly Mr. Clare's testimony, and that's pages 887 and 88. Carrier did not create this condition. They didn't know about this condition. Speed patched open seams on the roof. They never exposed the
But I
decking.
guess there was some issue or testimony as to from the interior, but as I understand it, it's a question of overlap that would be on the exterior, and how far it was overlapped, is that?
Correct, that's the testimony, that there was insufficient overlap. But I would refer, Your Honors, to Salem's own witness's testimony.
They
that it-
testified that there was no way of seeing it.
From the top or
until
the bottom.
decking was removed.
Yep, from the top or the
Or
bottom.
the interior, is that too?
I'm sorry?
And from the interior of the premises.
Correct, because the issue is how it overlaps or is connected to the beams.
But you wouldn't be able to see if you were looking from the.
Because the beam is in the way. Yep, and that is the crux of the argument with respect to Carrier's lack of negligence. Salem has gone to lengths to try and suggest that there is some question of fact. Well, using Mr. Salem's testimony that people patch decking. Well, sure, I'm sure somebody in the world could patch decking, but that's not what happened here. Also, we've pointed to the fact that the plaintiff was injured by the condition that his employer was hired to remedy. I mean, this was a roofing contractor that was hired to replace a roof that was leaking, and he fell through the roof, and his fall was not stopped or arrested because his employer literally didn't provide even one single safety device. And when this case was here a few years ago on the Labor Law 240 case, several of your honors were on that panel, and this court concluded that the failure to provide fall protection was a proximate cause of the accident. And that failure lay exclusively with Salem's. And we have an expert affidavit that clearly says, unrebutted, that that was a violation of workplace standards, negligence principles, and OSHA. But respectfully, Your Honors, this court doesn't even need to get to the question of whether Salem's was actively negligent. The fact that Carrier didn't create and didn't have notice of this condition, combined with the undisputed fact that Salem's directed, supervised, and controlled the injury-producing work, those two factors together are sufficient to entitle Carrier to summary judgment on common law indemnification. Anything further? Just briefly with respect to the unconditional language, this court, if it agrees that that language is improper, can modify the order and judgment under CPLR 5522. The order and judgment was that Carrier was entitled to complete indemnification. It should be unconditional because the liability issues with respect to the plaintiffs.
I think there was some confusion on whether there's a requirement of payment.
Correct.
Yeah.
We respectfully submit that if this court were to modify that language, it would not impact the ultimate ruling, which is that Carrier is entitled to complete indemnification.
Thank you.
Thank you.
Good morning, Your Honors. Tom Kowalik for Speed Motor. I'll be very brief. Your Honors, in regards to what Speed Motor knew and what it did before this accident, I think the record, frankly, is clear. And I'd like to quote right directly from it. In regards to what kind of work was done relative to the replacement of the decking before this accident, by either Speed Motor or Carrier, Mr. Clare clearly testified, and here's his testimony on page 887, lines 7 through 10. Question, prior to 2017, the year that the accident occurred, Had anyone in your maintenance department replaced any of the decking on the roof of 275 Woodward Avenue, the location of the accident? Answer, no. I think that's clear evidence that no decking was removed by Speed Motor. No new decking was installed by Speed Motor in regards to that roof before the accident occurred. In regards to why the decking seen from below, so seen from the floor of the warehouse, if you look up, some decking was of different color than other decking. And Carrier takes that, sorry, not Carrier, but Salem, takes that to mean that somehow Speed Motor or Carrier must have swapped out decking at some point in time, even though Mr. Clare clearly testified that that did not occur. Mr. Clare testified that, and I'll quote briefly, question, so what's the basis of your knowledge that there were obvious repairs done to the building from before when Carl, Mr. Severino, owned it? Answer, there was different colored decking. Question, and you could see this by looking at it. Yeah. Okay, and you have no idea who did those repairs, correct? I do not. Clearly, those repairs were performed prior to 2004 when Carrier purchased that property. The record is very clear on that point. Your Honors, just a couple arguments that the plaintiff or Salem's made in its reply brief that I'd like to comment on. One is that there's some sort of issue of fact as to proximate cause. Justice Smith and Justice Newmoyer said on this case in 2019, clearly the court determined the proximate cause was the fact that no safety devices were provided to the plaintiff. We now know that the sole party that had an obligation to provide those safety devices is Salem's. It's not Carrier, and it's certainly not Speed Motor. Furthermore, in regards to the proximate cause argument, let's think about the roles of the parties in this case and what they knew before the accident occurred. Prior to the job starting, Salem was aware that the roof was old, it was leaking, the decking was corroded and damaged. That could be seen from below the roof when one was standing at the warehouse. They appreciated the fact that portions of the decking were replaced in the past and that the roof was at least 30 years old. After the job started, but before the accident occurred, Mr. Maida, the foreman of this job, the guy in charge of safety, replaced roughly, or his crew replaced roughly 15 to 25% of the decking before the accident took place. And the way it's done is the layers of the roof get stripped off, the decking is exposed, and they make a determination whether that decking should be replaced or not. And they replaced up to 25% of the decking, so up to 25 out of 100 panels that they exposed before this accident due to either rust or insufficiency relative to the overlap on the beams. I'll wrap up really briefly, Judge Smith. The reason those decking panels were replaced is because they could not support a new roof. They also could not support a weight of a person standing on the decking. So it had to be replaced. They also knew at that point in time that the job was relatively dangerous. There's up to 25% of these panels that were not capable of supporting a weight of a worker. Armed with that knowledge, Your Honors, Salem utilized no anchors, no raptors or portable anchors, no harnesses, and no netting, even though netting was feasible because it was used after this accident. As a matter of fact, in this case, Mr. Maida, the foreman on this job, an employee of Salem's, tells the plaintiff hours before the plaintiff falls 30 feet onto the ground that he being the plaintiff, should leave his harness in his vehicle and not to bring it to the work site. Your Honors, I think there's overwhelming negligence of one party in this case. There's absolutely no direction, control, or any safety responsibilities on the part of Carrier and Speed Motor. and I think proximate cause is determined before by this court is clear. So I would urge you not to disturb the lower court's findings relative to negligence on the part of Salem, no negligence on the part of the defendants, as well as the proximate.
Thank you very much.
Thank you.